I'm Sarah Ball. I'm a partner in the employment team at Birketts, and this is part of our Global Mobility series of webinars. And you might have attended our first webinar in this series earlier in the year, which focused on employing workers in France. If not, and if you're interested in that webinar, please contact us at the end of the session and we can send you the link. But today it's all about the US, and we're going to be looking at sending UK employees to the US, how to go about that, what you need to know, but also the scenario where you wish to recruit someone who will be US based. And I'll introduce our panel properly in a moment. Whilst we're waiting for everyone to join the call, because that can take a few moments, I thought I'd tell you a little bit about Birketts. In case you don't know us, and also to let you know about a new initiative that we've launched called Birketts Resolve. So Birketts is a really large and very well-established law firm, having been in existence for over 160 years. We have over 700 lawyers covering pretty much all different types of legal advice. We've got 45 lawyers in the employment team itself, so we're equipped to assist you with all different types of projects and work streams, including disputes, which is where Birketts Resolve comes in. So recently, and particularly post-pandemic, and I'd be interested to know if Nan's experienced the same, we've noticed that increasingly we're asked to assist with really complex and seemingly intractable disputes in the workplace that employers are struggling to navigate. And so we've launched Birketts Resolve in response to this. And this brings together a number of different work streams. So an investigations team of qualified and experienced employment lawyers who are dedicated to investigations, qualified mediators who are also highly experienced employment lawyers. So they've seen every type of dispute and personality out there. And also outsourced HR consultancy services for when you need a bit of extra support. And then we have a training program called Shaping Excellence. So if training needs are identified as part of the resolution process, then we can also assist with that. So I'm hoping that everyone who's now going to be joining this webinar has joined. Just a few housekeeping items before we get started. So the session is being recorded. We do encourage questions and discussion, and there'll be time for this at the end. And the way we'll manage those questions will be via the chat function. So please, if you've got any questions, just drop them into that chat. We'll do our best to answer them at the end, but we will be sticking to the timing in the invitation. So if you've got any questions that we don't get to, you're very welcome to email the speakers after the end of the session. So right, let's get started by introducing the speakers. Firstly, to introduce myself. For those who joined right at the start of the webinar, you'll have heard that me say that my name's Sarah Ball. I lead the employment team in the London office of Birketts, and I'm also the lead for the employment team's international practice. And I'm absolutely delighted to be joined by a truly distinguished and international pair of speakers today, with Nan Sato joining us from Japan and Caroline Esser joining us from Chicago. So it's been an interesting mix of time zones for this webinar. Nan, would you like to take a moment just to introduce yourself briefly?
Yes, thank you, Sarah. Hi, my name is Nan Sato. I'm a partner at Phillips, normally based in its Philadelphia office, but also now managing the Tokyo office. So I'm traveling between the US and Japan pretty frequently. I also co-chair our firm's international practice group, and we frequently help international companies with their US legal issues, as well as US companies with their global employment considerations.
Great, thanks, Nan.
Sarah?
And Caroline.
Hi, all. I'm AGC of HR products at Rippling. So that includes advising our EOR or employer record product, as well as our PEO or professional employer organization in the US. And before moving in-house, I was a litigator at Latham & Watkins.
Thank you. So, just looking forward to this discussion with Nan and Caroline, and I think just a recap on what we're looking to cover today. So, we're looking to cover scenario where you've got a UK employee who you might want to send to the US and what you might need to think about, or a scenario where you just want to recruit someone who might already be US based, but you're a UK employer. How might you go about that? So we're looking at those two different options, although there's a huge amount of overlap between those particular discussions. And then we were going to have a look at the options available to UK employers who are looking to employ someone in the US. And when we spoke before the session, we agreed that there's broadly sort of 4 core options. So you and I will run through 3 of them, and then Caroline and I will have a look at the 4th, if that's okay. So first of all, we thought we would look at direct employment. So where a UK company employs the individual who is based in the US. And that is something that's absolutely possible to do, isn't it? There's no legal barrier to that happening, but there's obviously quite a few different considerations to take into account if you're going to do that. And first of all, if they are a UK employee, a UK resident, there might be some immigration issues with having somebody work from the US. And could you just give us some of the headline points about what they might need to think about there?
Yeah, so you're right. There's no legal barrier to hiring somebody in the US directly through your UK legal entity. However, there are several considerations you need to keep in mind, including tax, liability protection, and the ease of administration. So from a tax perspective, permanent establishment is always a big concern, where you don't have a local entity, but you have people working on the ground in the other jurisdiction representing your interest on an ongoing basis. Depending on the employee's roles and responsibilities, the risk might be higher or lower, but it's never zero in that situation, right? So the UK entity needs to be very mindful of the PE concerns. From a liability perspective, normally we tend to recommend setting up a local entity. I think we'll discuss that option later, Sarah. But to have your UK entity be the direct employer means that they will be responsible for all the employment-related liabilities in the US as well. So they might have to, face claims and defend itself in the US court, which oftentimes is not desirable for a UK company. And also just from a practical perspective, administration, right, running the benefits and running the payroll in the US directly with your UK entity is practically very challenging.
Yeah. I think the permanent establishment thing is often something that gets overlooked in the first kind of flush of seeing, you've got someone who you really want to send to the US or recruit in the US, but perhaps they have particular skills or experience that you're really trying to get hold of for your company. And often it starts with looking at employment, whereas actually tax is probably a good place to start. Are there any... The permanent establishment risk is a risk around corporation tax, so the potential for having to account for some of your profits made in the US, to the US authorities, and that's something that everybody's always trying to avoid. So I think that's a good point. And I think the administrative side as well, it's just kind of navigating a system that you're not used to in terms of payroll and deductions and so forth. And whether that's something that you're completely comfortable with. If you're for a sort of a UK resident person, what sort of visa might they need to work in the US, and are they likely to be able to get it?
Yeah, I think that's another consideration for whether you want to set up a local entity or not, right? Because a US company needs to sponsor the worker's visa, oftentimes in these professional contexts. So a UK-based company without US operations cannot sponsor a worker's visa in the US. Normally, in a situation like this, we would be looking at H-1B, which is skilled workers visa in the US, and L-1, which is a multinational manager or skilled worker, highly skilled worker, or potentially an E2, which is an investment-based visa, where the company, if there's a local entity that's owned 50% by a certain nationality, and the employee also comes from that country, that's also an option. But any of these options would require a local US entity to achieve.
Yeah. Okay. And in terms of running the payroll and understanding what deductions need to be made, obviously in the UK, we're used to a system in terms of health where we have a national health service. But in other countries, in the US included, there's potential for insurance to be needed. Is that something that how does that operate in the US? What's typical in terms of what's offered?
Yeah, so I think there are two components there. In terms of payroll taxes, of course, you have state and federal taxes, and a component of that is called FICA tax, which includes Social Security and Medicare. And then there, on the top of it, there's state-run disability, paid family leave, unemployment, or local income tax deductions. So that all comes out of your payroll. But there's no national health system in the US, as you know. So oftentimes the employers would offer to cover the cost of private insurance to cover, for employees' health. But that is not a mandate. It's not a legal requirement by any means. It's just market practice, and most mid-sized to larger employers would offer that. And in addition to that, we also don't have a pension system, a national pension system. So it's a private system called 401k, and I believe Caroline might get more into that later. But it's, again, completely voluntary, and it's a contribution usually both from the employee and the employer to the scheme that the employees can take advantage of after they retire.
Is there any sort of unemployment coverage or anything else that you have to provide as an employer?
Yeah, so unemployment insurance is a part of the payroll deduction, and it's usually at the state level, and it's required by the state law to you contribute to a state unemployment fund, and unemployed workers can take advantage of that. In addition to that, there's also workers' compensation, right? So for most workers, each state, and not the federal government, the state runs the workers' compensation scheme, and state agencies set the rules and either supervise the private insurers to provide the workers' compensation insurance or sell the coverage themselves through a state-run fund.
Okay, great. So you mentioned the 401k pension pot. Are there any other benefits that are either mandated or recommended or typical that you would often offer as an employer in the US?
Sometimes you may see short-term disability or long-term disability insurance, and travel insurance, sometimes catastrophic disease insurance. But again, those are icing on the cake. They're not required by law, and many employers choose to provide them just as employee benefits. That's optional.
Okay, great. So in terms of you're looking at inviting your employee to start employment or to move from the UK to the US, what sort of documentation would you expect to see? Because obviously in the UK we normally have a quite comprehensive contract of employment that sets out an awful lot about obligations on either side, and then normally a pretty substantial staff handbook that sits behind that with some mandatory policies in there. But I think it's quite a different sort of structure in the US, isn't it?
Yeah, definitely from a contract perspective, because we have employment at will in the US. Some of you might be familiar with that. It's a very unique system to the US, right? So because of that, most employees don't have a contract. What they have is a very simple offer letter, oftentimes 1 or 2 pages, and just says, you're starting on this date and this is your salary. We're covering your 401k and you're at will. That's pretty much, the content of the offer letter that offers both the employer and the employee the flexibility to end the employment whenever they want and for whatever reason they want, as long as it's not discriminatory. So oftentimes we would see from our international, especially UK clients that come into the US wanting to use their UK contract and say, we really think there should be a termination protection, should we build it in? Our advice is usually no, because if you have the freedom, why handcuff yourself, right? There are situations, of course, for example, in executive situations where you might want to have a more comprehensive contract with the CEO or CFO of a company. And you can always structure that, but I would say that's a very small percentage of employees in the US.
Yeah, and I sometimes seen sort of side agreements in the US that cover sort of confidentiality, IP, maybe some post-termination restraints. Is that quite common, or is that just the sectors I've typically worked in?
Yeah, that's extremely common because we don't want to drop those into necessarily the offer letter itself, but to protect the company's confidential information, trade secrets. We often draft a pretty detailed and lengthy, restrictive covenant and confidentiality agreement to go with the offer letter. And, that's common practice in most states.
One of the things that all three of us have talked about prior to this webinar was the fact that you've got the federal versus state to cope with as a US employer. Again, not something that we're particularly used to. Are there any examples you can give of, or just some general information around which states have more comprehensive employment laws? Are there any sort of oddities in some of those laws, and which are seen as sort of extremely employer friendly?
Well, in terms of being employee friendly and states having pretty extreme employment laws, everybody thinks of California, right? So I would say it's closer to the European system than to the rest of the US in certain senses. But generally speaking, just to back up a little bit and explain the system, it's a 3-tiered system in the US. So it operates on the federal level, the state level, and then there's also the local level. So this creates a pretty complex regulatory environment where the employers must comply with multiple, sometimes conflicting sets of requirements. So on federal level, there are laws like Title VII, which is the law that prevents discrimination at the workplace based on race, color, religion, sex, and national origin. And then there's the Americans with Disabilities Act that protects disabled employees. And then there's the Fair Labor Standards Act. There's also the Family and Medical Leave Act and the Age Discrimination Act that protects workers over 40. So these are the federal laws that basically set a floor for the employee rights. And the states and the local governments can provide greater protections, and oftentimes they do, but they cannot reduce the minimum standards established by the federal law. So, states, more progressive states like California and New York have enacted laws that are a lot more protective for the employees in these areas. To give you some example, minimum wage laws, for example, in many states, the minimum wage requirements are much higher than the federal requirement of, I think currently it's probably $7.25 or something like that. There are additional areas of anti-discrimination protections, and federal law when it comes to family and medical leave, it only requires certain employers to provide these leaves unpaid, but many state laws require the more employers to provide paid leave, and also workplace safety and workers' compensation. And on a local level, you see, cities like New York, for example, having a lot more ordinances on the top of state law. So, there could be things that requires paid leave for certain workers and give them mandatory accrual sick time. And there's fair scheduling laws that makes work schedule more predictable for retail and hospitality workers. There's hotel worker protection laws. So there's like a whole range of different types of laws at the city level or municipal level as well.
Okay, and those are sort of based around different industries. That's quite interesting. Yeah, we talked about the fact that it's really easy to terminate in the US compared to many other places, and certainly compared to most of Europe. But the flip side of that could be that because you've got very strong anti-discrimination laws, that there's a bit more of a push towards making those kinds of claims, I assume, particularly because, those can come with a very high kind of set of damages for the employee if they succeed.
Yeah, exactly. So it's very easy to terminate employees, but the flip side of it is the proliferation of discrimination lawsuits, right? So everybody nowadays can find a ground to claim discrimination. So there's, especially in places like California, the courts are very, very busy with discrimination claims.
Yeah. And restrictive covenants, again, we've touched on those briefly, and the fact they're often in a kind of side agreement to ensure you get those sort of protections, even though you don't want to put it in the offer letter. There's been a lot in the press in both the US and the UK about restrictive post-terminate, and particularly non-competes, I think, in the past year or so. The British government had previously suggested they might limit non-competes to a maximum of 3 months, and that legislation hasn't yet come in, but it may still do. And at the same time, I know there's been a lot of furore going on in the US about restrictive covenants. Are there any states where they're prohibited, or any states where there's extremely restricted?
Yeah, as you say, there has been a lot of development in that space. The FTC issued a rule which got struck down by a Texas court. So as it stands now, restrictive covenants are enforceable in most states, as long as they're drafted in a way that's reasonable in terms of time, scope, and geographical area. And I think in that sense, it's very similar to the UK. There's probably only a handful of states, of course, including California, that prohibits post-employment non-compete. But even in those states, creative strategies can be used to protect the company's interest. For example, you can draft, like you're saying, we can have a long attachment to the offer letter where you draft clauses on confidentiality and trade secrets to kind of achieve similar goals.
Okay, well, I think we've pretty much covered everything there is, or that we can actually get through in terms of the webinar for direct employment. So just a quick look at self-employment. Now, it's often tempting to go down this route when you're recruiting someone abroad and say, well, you can be a consultant and then I don't need to think about taxes. I don't need to worry myself about any of that. I'll just send you the money and you can account for anything that needs accounting for, and you're self-employed, so you won't have any rights. So that's fine. But what does self-employment look like in the US? Would you say it's kind of similar to the UK, or is there some sort of specific recommendations you'd have around getting it right?
I think people think of the US as this free market kind of place and anything goes. But when it comes to self-employment and working as a contractor, there are actually a lot of restrictions for the employer. And in our practice, we have seen many cases where the employers received audit letters from the state's Department of Labor because they have received a claim either from the employees themselves or the contractors themselves or somebody with knowledge of the relationship. So anybody can write to the Department of Labor, and if they catch wind of that, they will send you a letter and say, we've received a complaint and you have to respond within usually 30 days and explain the situation. So if you can't explain the situation well and prove that they're indeed contractors and not misclassified employees, you're facing an administrative fine of thousands of dollars per occurrence. Plus, of course, unpaid taxes, social contributions, and related penalties and interest. So it's actually pretty serious in a lot of states, but again, more serious in states like California and New York, where, in California, for example, they have what's called an ABC test to basically, review the factors that would make somebody more of an employee than a contractor. So yes, that's definitely an area that, a lot of foreign companies tend to overlook, but it's pretty risky.
Yeah. Okay. Yeah, I think sometimes companies feel more comfortable getting it wrong in a different country than they do in their own, where they know more about it. So it's always good to kind of educate yourself on what the risks actually are. So we've looked at direct employment, self-employment, and the third option we sort of briefly discussed now was setting up a US entity, if you think, and that might be something you might consider if you think there's going to be a number of employees you want to take on, or if you've got concerns about corporation tax issues. Can you just sort of briefly tell us what that might look like and what that entails?
Yeah, so setting up an entity in the US is very easy and very fast. A lot of foreign companies don't realize that they think it's this big endeavor that's going to cost them, tens of thousands of dollars, and it's going to take months. That's not the case. So when a company has employees or operations in the US, even if it's just a small number, we usually recommend them to set up an LLC at least, and that can be set up within a matter of days and requires no minimum capital contribution, and the foreign shareholder or owner can do that. And the setup cost is, if you use one of the registered agent companies, it could be less than $1,000. If you use a law firm, maybe a couple $1,000. So it's really pretty reasonable to do that. And on the back end, as long as you don't have complex debt and outstanding taxes, it's not difficult to dissolve them either. So there's more benefit than that detriment, I think, in setting up a local entity.
Great. Well, thanks very much for walking through those three options with me, Nan. I'm going to turn to Caroline now because she can help me with option number 4 that we identified, which is looking at having someone else engage your employees. And I know that there's various different services that your company offers, Caroline. I think one of the things that we're perhaps not that familiar with in the UK is what all the different terminology means. So you've got PEO, EER. What does all of that mean, and what kind of service does that entail?
Yeah, definitely. So we do see a lot of conflation of these terms, but for us, EOR means employer of record. That's a global product. And in the EOR setting, Rippling or whoever the EOR you're using is the sole employer of record. So that means we send out the employment agreements, any mandatory policies, enroll employees in mandatory training. And if things don't work out with the employee, we also handle the offboarding or termination, of course, in consultation with the customer, but we send out all of the termination documents. We also handle payroll taxes, manage the employee's leave requests, and provide access to expert HR advisors who are on the ground in the relevant countries. So the EOR is kind of the most hands-on, full-service product, and it's a great option if you don't have a local entity in the country and you aren't sure you want to go through the effort and time of setting one up. Like Nan was saying, it's actually pretty easy in the US, but that's not always the case. In some countries, it's very expensive and very time consuming, and it is hard to dissolve an entity once you have one. So an EOR can be a great option there. It's also a great option if you're just trying to test out a market, like you're not sure if you want to have a permanent presence there. Um, so that's the EOR. The PEO, or the Professional Employer Organization, that is a US only product. And PEOs are actually regulated in the US, so they're federally recognized by the Department of Labor and the IRS. So Rippling, for example, is licensed in all 37 states in the US that have licensing regimes. Very different from the EOR, which is kind of a newer model that's not directly regulated in the US or any country. Um, and the PEO is a co-employment model. So it's for companies that do have an entity in the United States, but they want some help with basically HR services and payroll taxes. And a big benefit of the PEO is that you get access to the PEO's large group benefits. So to our discussion earlier about how there's a private health insurance market in the US, this is really helpful to smaller companies or medium-sized companies that want to be able to compete with the Googles and Apples of the world, who have super rich benefits. But on their own, they would only be eligible for small group plans that are not as rich, but through the PEO, they can get really rich large group benefits. And then we also provide access to our workers' comp and EPLI, or employment practices liability insurance, through the PEO. So if an employee files a claim against the PEO customer, or if it's covered under the policy, our insurance would kick in, and then we would also provide claim management services. And again, we have a great HR team based in the US, who can provide best practice advice and digital workplace posters, employee handbooks, resources, HR resources for our clients to use. But the PEO is a narrower slice. Like, we are co-employers for a narrow slice of the employer responsibilities versus the EOR, where we're the sole employer.
Yeah. So is the model then that's most popular really just depends on what your needs are?
Yeah, that's right. I think if you have an entity in the US, the PEO is probably the best fit. If you do not, EOR. And then there's yet another option, which it sounds like Birketts might offer a similar service of just HR services, or some companies call it ASO. Um, so Rippling is not the employer or the co-employer, but we just provide payroll tax, HR services, access to EPLI insurance. So it's kind of like the most lightweight version of those other two. Um, and the nice thing, if you're using a company like Rippling, is that you can really toggle between these solutions as it works for you. So maybe you start by using the EOR and then you decide, oh, the US is an amazing market for our company. We really want to have a long-term permanent presence there. You can create your own entity, move to our PEO or move just to direct employment, use our payroll product without having to rip and replace the underlying technology. So the idea is that we can support you through whatever point you are in your company's life cycle.
Great. So as you're growing, you can kind of move between different products depending upon what fits. Yeah, because some people would be concerned that an employment through EOR might not be kind of a long-term solution if they might feel like it dilutes the culture of their business. But I guess that you work quite closely with businesses to try and ensure that there's the same flavor, regardless of sort of which country you're in.
Yeah, of course. We definitely work closely with our customers to take into account their business needs and priorities. But you do raise a good point. Like a company does give up some amount of control when they are using an EOR, because they aren't the employer on paper. And they might, a client might have an approach, let's say to a redundancy or a global risk, that where they want to give X amount of severance globally, but we have to think about local compliance in each of the jurisdictions where the customer is using the EOR. So there is sometimes a little bit of back and forth there to make sure that, part of our job as an EOR is to make sure the customer is staying in compliance with the local laws.
Absolutely. So you get the most sort of hand-holding with the EOR product though. So if you're very nervous or just kind of, dipping your toes into a different market, that might be something that appeals.
Yeah, I've heard many customers say that one of the best things about an EOR is how quickly you can hire someone. Like you can just
Right.
go in that day, put in the information, maybe you have to do a medical check before the person starts, not in the US, but in other countries, but they can start pretty dang quickly. So you don't have to do kind of all of that legal research on what are the requirements in the country, draft a locally compliant employment agreement, figure out social security contributions and payroll, because we do all of that for you. So it's definitely like the way to get someone the quickest when that's what the company needs.
Yeah, I
But
think that's
maybe,
really
yeah.
interesting. Oh, sorry. Yeah, no, I
Oh,
think
no,
that's
go
really
ahead, go ahead.
interesting because I think I often work with businesses who are interested in EORs and particularly sort of a bigger EOR like yours, where you're present in so many different countries, where they can see that they want engineer in Portugal and then an engineer in the US, and they're kind of looking at loads of different countries, and they're not really looking to establish a proper base in any of them. They're really just wanting to cherry pick that talent out of that country, and want the kind of the quickest and the kind of least risky way of doing it.
Yeah, that's exactly why we launched the EOR. We just saw amongst our customers this desire to hire the best talent wherever they are based in the post-COVID world. Um, and hesitance, I'd say, to put in the time and the effort to set up permanent presences in all of these countries where they were just hiring one great talent or, a handful of folks, but not looking to set up an office or a headquarters.
So we've talked a little bit with you and with Nan about insurances, social security, payroll. So I won't go into that anymore. But in terms of sort of state to state, you've sort of emphasized, both of you, that there's sort of different requirements that need to be taken into account. Can you just tell me a little bit about that from your perspective, Caroline?
Yeah, I completely agree with everything Nan said, and that definitely is something that both EORs, PEOs, and HR service companies can help with. There are, different reporting and registration requirements at the federal, state, and local level. And so we can help identify those obligations, but also help actually complete the reporting and registration requirements. So, for example, like for the PEO and HR services, we can help with registering with the Secretary of State or foreign qualification if the company is hiring folks in a state for the first time. We can help with EEO1 reporting federally, but also California pay data reports in California, so the kind of the state version of that. And then there are a number of city and state healthcare ordinances that have different requirements and reporting obligations, like the SF Healthcare Security Ordinance and Massachusetts Health Insurance Responsibility Disclosure. So there's all these like very specific requirements depending on where the employees are based. And that it can be nice to take a little bit of that weight off of your own back and by using a PEO or HR services.
Yeah, great. Well, I think out of, the 4 different options, we've gone through all the different kind of permutations, and obviously it really depends what you're looking for as a business in terms of what is going to be the best option for you. But I think, we've looked at the things to guard against and the things to think about. Have you got any final thoughts, Nan or Caroline, or are you think you've said everything you wanted to say as part of our discussion?
I think that we covered most of it. Yeah, I don't know, Nan, anything on your end?
Yeah, no, I think that was pretty complete. And obviously, just to highlight something we said, there's no one size fit all here, right? It's really the best option depends on the stage of your company and your long-term goal in the US. So it's always a good idea to talk to Sarah, talk to us about these different options and see what may suit your company best.
Great. Okay, well, thanks so much for the both of you. We're now going to have a look at whether there's any questions in the chat, and if so, we'll answer those questions, and then we'll look to finish on time in about 8 minutes time. So thanks very much.
Thank you.
Thanks.